So I'd like to turn your attention now to the analysis of Islamic law in modern financial markets. It in fact cannot be reduced to the study of a jurist's law or the discourse of Islamic jurists, the fuqaha. Why is this? Islamic law is in fact known as a jurist's law par excellence. It is a jurist's law because it was the jurist's authority to derive the law from the sources in keeping with God's word, with God's law, and to do so in an undistorted manner. This is quite different than a Western system of law, which is generally premised on developing law on the basis of principles and norms. One speaks today very often of the objectives of law, the maqasid al-sharia. But the traditional methodology of deriving law is known as the usul al-fiqh, and that's based on the sources of law. And the jurist derives the law depending upon the rank of jurist, in a way to deal with novel problems, in a way that is in keeping with God's revelation. And so, to analyze Islamic law from the perspective of juristic discourse, my premise here, and I think I'll go on to proceed and show you with quite substantial evidence that would not shine a lot of light on what is happening with the development, with the transformation of this legal system. The lay perception, in fact, may be exactly that Islamic finance is underpinned by the Sharia in its classical form. And if it is not, then perhaps it's considered to be un-Islamic. And that's quite clearly a problem for the industry. In fact, the transformation of Islamic commercial law challenges traditional assumptions concerning the articulation and ethical substance of the Sharia. This is due to the actors, processes, and formats involved in the modern articulation of the law, including its regulatory assimilation in municipal legal systems and jurisdictions, which are unparalleled. The legal hybrid that results from these transformational processes, such as legal standardization, cannot be adequately explained in terms of classical doctrine, or fiqh, the derivation of the law by the jurists. It is in fact the modern environment, the modern financial environment and its actors, which are the primary contributors to the law's articulation and implementation. Again, my premise, IFL is a globalized variant of Islamic law. It depends on the Sharia for its legitimacy, but not as a source for its legal development, which is quite radical. The sources, the holy sources of Islamic law are, from a classical perspective, the repository of law, that is the origin of lawmaking. And so the argument I'm making that in fact that is no longer the case, and we'll see that the question is if I'm correct in this assumption, what are the consequences for developing the law of the industry, or developing Islamic notions of law that can be applied to the commercial environment? And this could be applied across many areas of law, not just in the financial realm. If we're dealing with a fundamentally altered context, what is then the methodology of law that we need to develop so that the law is in keeping with its substance, its ethical substance and form. Well, if we view the lawmaking in this fashion, we're viewing legal and other actors through the prism of legal transplants, which is an academic concept I'm not going to trouble you with, legal pluralism and fragmentation of the law in the globalized economy. I'm not focused on structure here or hierarchy. Those are traditional ways of viewing a legal system. We have a Supreme Court and lower courts, and there's a hierarchy of lawmaking and a parliament. These are all very organized. In fact, the type of lawmaking I'm referring to is much more processual. It's about a process of lawmaking that ultimately may wind up in these hierarchical legal systems. But that is not generally where it originates. It originates in financial markets. Interdisciplinarity in this regard has never been so important, because an understanding of the law of Islamic finance requires an examination of its context. And to be able to examine that context really does require a knowledge outside of just the law. It requires a knowledge of finance. It would be good to know some sociology. It would be good to know history and language. And I think that really highlights the way in which the world has become so complex. So specifically, the book that I have written focuses on the role of the participants in the industry, on the commercial and investment banks, the law firms, the accountancy firms, sharia scholars and consultancies, nation states, regulatory authorities, international Islamic non-governmental organizations such as AOFI, the Accounting and Auditing Organization for Islamic Financial Institutions. It's always so long, it's a little tiring to pronounce it. And the IFSB, the Islamic Financial Services Board, as well as other market practitioners, rating agencies, for example. But market forces are equally important, as well as the power dynamics and power relationships, a field of research that usually lawyers really don't have a whole lot to do with. So let's look at some of the facts. The globalization of the economy, the rapid rise in international capital flows from industrial to developing countries over the past few decades is unprecedented. The short-term nature of these capital flows, as well as the unprecedented level of cross-border lending, distinguishes the modern period of the 1900s, which has sometimes been called highly internationalized. In fact, it distinguishes that from globalization, in which international linkages are rooted in long-term investment. In fact, the gross capital flows between industrialized countries, which is the sum of the absolute value of capital inflows and outflows, increased by 300% just from 1991 to 2000. A large share of this increase is attributable to the enormous growth in foreign direct investment and portfolio equity flows, rising by roughly 600%. Increases in these flows substantially outpaces the growth of the real economy, or the growth in international trade, which indicates a type of economic growth that is premised on finance and the returns from finance over manufacturing. That's not a very hospitable environment for Islamic finance, as you might surmise. When we talked about what Islamic finance is, it's the creation of value through the exchange of assets, or loaning money through the sale of tangible assets and services. When making money based on a financialized economy is the basic paradigm, it's really going against the current, if you will. And power relationships in the law, TNCs, transnational corporations, are major factors, in fact, in developing the legal environment in which they invest. The customs, the contractual undertakings, the legal systems in which they are headquartered often find their way into the legal systems of those areas of the world in which they invest, of those transactions in which they engage with. And the origins of the most influential transnational actors determine the particular characteristics and nature of the law so as to reflect its native legal background and traditions. The US and European states continue to dominate a large share of the world economy, and the proliferation of TNCs from these countries' financial centers facilitates the dominance of American and European international standards and contractual methods. Consider, for example, the westernized business environments of the Gulf countries. These are largely they're civil law environments, but also common law legal environments that are doing business much like you would be doing business here in Paris or in London. The leading states and the development of international law also plays a huge role. The structure and regulation of the global economy is powered by the most dominant region in the world, namely the North Atlantic region, comprising the United States, the European Union, and Canada. The economy of the North Atlantic, the most highly developed trade and finance corridor in the world, is the largest and wealthiest market in the world as well. It accounts for more than 50% of GDP, global GDP, and 71% of the outward stock of global FDI, or foreign direct investment. This delimits diversity, since the US and the EU are the rule setters, the lawmakers, the global lawmakers. And the role of the neoliberal economic paradigm, which is quite different than in Islamic economic perspective, creates a certain mode of finance, a certain way of doing business that makes it very, very difficult for Islamic finance to put forward its vision of doing finance. It also leads to common topics that lawyers might hear often, such as harmonization or standardization, and the best practices of these states as well. Best practices is something that needs to be interrogated, because best practice might not always actually be best. It might be most efficient coming from a particular part of the world in terms of the way business is conducted in that part of the world. So in light of this, I have some observations regarding the nature of Islamic financial law. Theorizers or practitioners of IFL seek to develop legal structures which embody authentic values. These are universal, timeless concepts such as equality, fairness, justice, and equity. The strategy is to situate Islamic financial law's development within the dominant textualist methodology, the methodology of deriving the law from the holy sources known as the usul al-fiqh, and the ancient discourse of renowned scholars. This is known as the fiqh. These are the treatises, the writings of the scholars. Classical contracts can be modified to give effect to classical values, or at a minimum not to transgress timeless rules and religious prohibitions. But authentic, original, or pure notions of the sharia or some other concept or value postulate cannot be mined from the past to be rehabilitated in the present, because such concepts reflect the value-laden perspective of the presently situated interpreter. As human beings, our interpretation of activities or statements depends on conventions, norms, and practices, and these are signified through language. But due to this, we are limited in our perception because of the limits of language within this universe of these very practices and conventions and activities. Language, in fact, places limits upon the interpreter so that our understanding of the different aspects of our lives shapes our perceptions, judgments, and opinions of the subject matter and the ways in which it can be organized, categorized, and made intelligible for an audience, the object of our language. This condition of intersubjectivity or ingrained bias is simply impossible to overcome. It is a condition of life. Yet authentic legal solutions continue to be sought in ancient legal treatises, while the role of context in determining the trajectory of the law is neglected. This legalistic focus willfully ignores the fundamental dynamism inherent in all legal systems, the ways in which context continually informs the substance and letter of the law. Its proponents hold fast to a false sense of certainty in the global system. But divorced from the contextual environment, scholars' understandings of the Sharia will not contribute to the development of a distinctively different or ethical financial services. And that is because it is the relationship between the actors and the social systems, the ways in which they mutually inform one another to generate a larger whole, that is the most salient feature in the transformation of the law. The complex interaction between actors, which we could note as fields of action, and subjects, which we could think of as Sharia principles, indicates that context is never static. Rather, it is self-generating. As actors take part in reproducing Sharia principles, environment, history, and imagination are woven into new contexts in which new material and social understandings are produced ad infinitum. It is a self-generating context. And I'd like to read to you briefly and very slowly and meticulously an excerpt from a book that I think is fairly clear, and it talks about the interaction between the local and the global in the transformation of the law. At first glance, economic globalization seems to be self-contradicting in that it generates global trends towards cultural, legal, and economic harmonization, while providing opportunities for articulating difference, particularly at the local level. In fact, this perception overlooks the self-generative nature of context, in which the global and the local are increasingly linked. Take neighborhoods as an example of viewing globalization from the ground up. Neighborhoods, in addition to their spatial and temporal realities of location and history, are conceived within a historically produced spatio-temporal neighborhood and with a series of localized rituals, customs, social categories, expert practitioners, and informed audiences. Neighborhoods are, in part, a product of our individual and social imaginations, fed by our experiences, practices, and conventions. But these imaginings of locality must be produced, maintained, and reproduced against a necessarily foreign background or context, which in turn infuses notions of locality with new ideas and influences. So the construction of locality requires ongoing imaginings of the foreign in both discourse and practice. There is a dynamic fluidity of linkages between the global and the local. And these increasing challenges are brought on by the effects of globalization, particularly when it is conceived as a feeling of belonging, a social recognition, or an ideological commonality. And so the book I've written shows the various jurisdictions' ways of dealing with this dynamic, their different approaches to Islamic finance, their varied efforts to modernize their legal systems, to restructure their economies. And these efforts are challenged not only by the forces of globalization, but in fact they represent a localized interpretation of globalization. And finally, I have one more excerpt, and then I let you off the hook, so to speak. Globalization ushers in a plurality of interactive legalities in municipal legal systems or jurisdictions. These are diverse ways which states choose to react to the unbundling of their territories, and more generally to the ways in which modernity continues to find new and unforeseen ways of articulating itself. Yet the engines of modernity remain genetically tied to the power structures of the North Atlantic and its predominant social episteme, neoliberalism. Beyond law and economics, the North Atlantic's myriad influences are unmistakable across a range of social interaction, whether it's language hegemonies, clothing styles, advertising techniques, films, art, armaments. And yet power relationships, while providing a general framework for conduct and possible outcomes, are conducive to entire fields of reactions and inventions. At their core, power relationships prompt insubordination or obstinacy, which are nothing other than means of escape. The desire for freedom, which is intrinsic to every human being, implies a strategy of struggle in which the two forces are not superimposed, do not lose their specific nature, or do not finally become confused. Heterogeneity represents ongoing struggle similar to the life cycle, which continues indefinitely to exert itself within the dynamism of power relationships. And so Islamic finance is conceived as an expression of struggle against the injustices and inequalities of the dominant economic system. A legal pluralistic context illustrates the ways in which notions of the Sharia are transformed into dynamic power relations of overlapping legal systems. And finally, Islamic finance offers an interesting case study for examining the trajectories of globalization and the possibilities of legal change in the global economy. Thank you. Merci.